Mr. Hardin, you can continue.
Thank you very much, Your Honor. Stella, can I have hard copy exhibits for the court and the other side on Exhibit 571? And can you give the witness one so that it doesn't have to be put up on the screen?
Is this already in evidence?
It is not. That's what I'm going to seek to introduce. Thank you, Your Honor. So now, without going in to specific contents, do you recognize this exhibit?
Yes.
And without talking about the contents as to what it says, how would you identify it in terms of what it is?
This is a text message that was sent
microphone, I'm sorry.
This is a text message that was sent by the group of us to the Attorney General.
All right. And does it also contain the Attorney General's response?
Yes.
Are you aware of people, of any instance where there's been criticism that you did not seek to meet with the Attorney General? Are you aware that there's been that criticism?
I'm aware of that, yes.
All right. Now, Your Honor, we move to introduce 571, the understanding this witness participated in sending this along with the other group of people we've been talking to as the whistleblowers.
Any objection?
No objection, Judge.
Continue.
Right, can I have it up on the screen, please? The first page, would you show who all is, would you, for the record, explain who all it says is sending this?
The beginning at the top of the page, Lacey Mays, Deputy for Administration, is sending this email, which contains a screenshot, to Jeff Mateer, Blake Brickman, Ryan Vassar, Ryan Bangert, myself, Mark Penley, and Darren McCarty.
All right, if you would look at the screenshot on that first page, and we turn, does this exhibit contain a screenshot of the text messages that you as a group, the addressees up at the top, sent to the Attorney General?
Yes.
And did you send it on what date, if you would look up there?
The date is not listed, but this would have been...
The screenshot is dated, is it not?
The screenshot...
Yeah, the first page.
Yes, this is the email is dated October 1st.
Right. The email has been sent around, but if you look at the second page of this exhibit, does it contain correspondence with where each of you let me back up. Strike that, and I apologize, Mary, ma'am. If you just give the jury the background of why y'all sent this and when you sent it.
Yes. We sent this message to the Attorney General after we had made a good faith report to the FBI. We wanted to speak with him. We wanted to bring him back to the office, or we wanted to invite him back to the office to speak with us so that we could address these concerns head on. We were hoping that we could finally resolve these issues and, in our view, end this unlawful use of our office's resources.
All right. Now, the screenshot was dated October 1st, and in fact, your group went to the FBI, I believe you testified, on September the 30th, correct?
That's right.
This email that Jeff Mateer sent on behalf of all of you, would you read that out loud, published to the jury, please?
The text message?
Yes.
Yes. Jeff Mateer at 12:49 p.m. General Paxton, yesterday, each of the individuals on this text chain made a good faith report of violations of law.
Nice and slow.
I'll begin again. General Paxton, yesterday, each of the individuals on this text chain made a good faith report of violations of law by you to an appropriate law enforcement authority concerning your relationship and activities with Nate Paul. We request that you meet with us today in the 8th floor conference room at 3:00 p.m. to discuss this matter.
Now, at that time, since when it says yesterday here, and I believe you testified that the two of you went to the FBI on the 30th, correct?
The group of us did.
Yes, and then on the 1st, you send this text. So when we see on there today, 12:49 p.m., this message from Mr. Mateer on behalf of all of you would have been sent on what day?
The following day, the 1st.
October the 1st. And at that time, did you know whether or not the Attorney General was back in Austin from his trip out of town?
Yes, my recollection is that he had returned late the previous evening.
Late the evening of the 30th?
Yes, that's my recollection.
Okay. Would you publish to the jury what he responded to you about 3 hours after you sent it?
Yes, at 3:08 p.m., Jeff, I am out of the office and received this text on very short notice. I am happy, as always, to address any issues or concerns. Please email me with those issues so that they can be fully addressed.
And so did you email him with those issues?
I don't believe we did. I don't recall. We wanted to meet with him personally.
And if you did not, why would you not have?
He was well aware.
And how did you take that, asking for the issues?
I interpreted that message as he was not going to engage with us on this.
Did he ever reach out to and try to?
No, not to me.
And as a former deputy first assistant, you remain still with the office, available to talk to him for how long?
I remained with the office until after the 2020 election in November, early November.
At any time after you sent that text, did the Attorney General ever attempt to discuss any of these issues with you?
One time.
When was that?
I had turned in my notice of resignation. I was in the process of gathering up the things in my office, and I was alone in my office, and he walked into the office unannounced and closed the door behind him and was pacing to and fro in the office. He was very agitated, in my view. And he said to me, "Ryan, I just want you to know that you're only sitting in this office today because of me."
What else did he say?
He said, "This was not Jeff Mateer who put you here, it was me."
He said what?
He said, "Jeff Mateer didn't put you in this office. It was not his decision, it was my decision. I put you here."
Okay.
And it was a very odd conversation. I wasn't quite sure how to respond, so I just told the Attorney General that it was my hope that God would work things out in the end. That was the only time that he spoke to me alone about these issues, and that was it.
What is your observation as to whether in encounters of unpleasant or difficult issues, the Attorney General's characteristic is as to how he acts in issues of conflict or whether he avoids them?
Objection to relevance.
Sustained.
After you left, could you describe for the jury the impact of all this has been on you?
Yes, that month was a very unsettling month. I was waiting to be terminated. Instead, I just had my job duties stripped from me and was left more or less a man without portfolio in the office. I watched as my fellow whistleblowers were placed under administrative leave and investigated. I watched as certain members of the staff, the new staff, treated them in a belligerent manner, including myself, and ultimately I resigned. It was incredibly heartbreaking because I had believed in Ken Paxton and what he had been doing for years. I had moved my family here to Austin specifically to go to work for him. And I watched all of these things that we had done as a leadership team slowly begin to unravel. And it was absolutely heartbreaking to see that happen to an office that had been, in my view, a beacon for the conservative legal movement for years.
Have you noticed he's not even here today?
Objection to relevance.
That's very relevant. I want the record
Objection
to
to
reflect.
relevance.
If I could, I'll ask that question again.
Sustained.
All right. I want the record to reflect that Attorney General Paxton was not here entirely. I'm just making this for the record. I think we're entitled to point out.
I'm objecting to the attorney testifying.
Excuse me, let me finish, please.
Quit talking over each other. Court reporters cannot record. I sustain his objection.
Yes, sir, I understand, and I'm not any longer trying to ask that question. I do want the record to reflect that neither yesterday nor today has the Attorney General graced us with his appearance. That's all. I wanted to make that statement, please, for the record. I thank you very much, Your Honor. I'll pass the witness.
Judge, may I have a moment to just prepare my exhibits up on the bench or the
Yes.
podium? May I proceed, Judge?
You may proceed.
Mr. Banger, we heard a lot about your background. Obviously, you have a very esteemed career and resume, correct?
My resume is what it is.
Okay. Mine's not like yours, and so I'm just going to try and do a courtesy to you and ask you short and simple questions, okay? And I'd ask that if I ask you a yes or no question, that you simply respond yes or no, all right?
Understand.
Okay. Now, you are currently represented by an attorney, correct?
I am.
Okay. That attorney is Johnny Sutton.
Yes.
That is the same attorney that represents Jeff Mateer, correct?
It is my understanding that he also represents Jeff Mateer.
Okay,
Yes.
So you and Jeff Mateer both have the same attorney.
We do.
Okay. As a matter of fact, Mr. Sutton is here today in the building, right?
Yes.
He's probably watching your testimony.
I assume so.
Okay. And as a matter of fact, the two of you were just in the restroom together about 15 minutes ago?
You would know that because you were there too.
I know, right? But that's a yes, correct?
That is a yes.
Okay. So you guys have been in contact during your testimony in this trial?
We have.
All right. Now, you stated on direct examination that you did not provide any statements with regard to what you've testified in court today, right?
Could you please reframe? I don't understand the question.
Sure. And I think the record reflects when Mr. Harden asked if you made any statements in this case, and when Judge clarified if you had made any statements before this testimony, you said that you hadn't.
I do not recall testifying to that effect.
Okay. So you've made statements previous to your testimony today, right?
Again, when you say statements, have I spoken to anyone?
I mean, you have made an out-of-court statement, Mr. Bangert.
Are you talking about under oath?
I'm asking you yes or no, have you made statements about this case to anyone?
You may answer the question. What's your objection?
My objection, Your Honor, is if he would just please express what he means by statements. That has a legal significance and a practical one.
Overruled.
This witness is not aware of the issue.
Overruled. Answer
Yes.
the question.
So
It's a yes or no question.
it's not a yes or no question.
Well, then
sir.
let me ask you a more specific question. Were you interviewed by the House Board of Managers in their preparation investigation of this case?
Yes, I was.
Okay. Were you interviewed by Mr. Harden and Mr. DeGuerin prior to your testimony for this case?
Prior to my testimony today?
Yes.
I was, yes.
Okay. So those are two statements that you've made to people about your testimony in this case, right?
I'm not trying to fight with you, counsel. I'm simply pointing out that the word statement carries legal significance, typically
hearsay,
under oath.
Well, hearsay is
Those are not under oath.
Yes.
Witness,
Yes, ma'am.
answer the question, not argue with the counsel.
You've made 2 interviews prior to testifying today, right?
I have given interviews, yes.
Okay. 2 of them.
I have spoken both with the House Managers Council and I've spoken with Mr. Hardin and Mr. DeGuerin.
Yes or no, Mr. Banger? Were either of those interviews recorded?
No.
Did you ask that those interviews not be recorded?
No.
Did your lawyer ask that those interviews not be recorded?
Not to my recollection, no.
So you don't know why they were recorded? Why they were not recorded?
I do not.
Okay. If Mr. Hardin or Mr. DeGuerin had had any objection to you being recorded during your interviews, would that have been a problem, yes or no?
I don't understand the import of the question. Would that have been a problem for me?
My question is, if Mr. Hardin or Mr. DeGuerin had said, Mr. Banger, you're giving an interview with regard to testimony in an impeachment trial, can we record you? Would that have been a problem for you or Mr. Sutton?
I can speak for myself. I would have no problem with that.
Okay. And despite your lack of objection to that, Mr. Hardin and Mr. DeGuerin chose not to interview you during your interviews with regard to this case?
Chose not to record me.
Yes.
I assume that was their choice, but I was not recorded.
Okay. And additionally, prior to that interview, when you met with the House Board of Managers, safe to say you wouldn't have had an objection to them recording you either, correct?
I can't think of any at the time, no.
Okay. And it just so happens that the House Board of Managers, the investigators in this case, chose not to record your statement either.
As far as I know, they did not.
Okay. So you would have to agree that there are a lot of things that you testified to when Mr. Hardin was directing you that we were hearing for the first time on this side of the trial, correct?
I honestly cannot answer that question. I do not know what you know and what you do not know.
Okay. Well, you had information that you produced actually to both sides of this trial within the last 2 days, correct?
There was a text chain that was produced by my counsel.
Okay. We didn't see Mr. Hardin produce those text messages during his direct, did we?
Mr. Hardin producing his text messages to whom?
During his direct examination of you, he did not ask you about text messages that you produced yesterday during this trial. Yes or no?
No, he did not.
Okay. Your Honor, may I approach the witness?
Yes? Don't speak to him now. Just give it to him and then speak from the microphone. Thank you, Counselor.
I'm handing you...
Hold on. Everyone wants to hear you.
I'm handing you what has been pre-marked as Attorney General's Exhibit 1000 and I believe 3, correct?
It is marked AG 1003, yes.
Okay. Now, you recognize this document, do you not?
I do.
These are text messages from your cell phone, right?
Yes.
You produced these to both sides in court yesterday.
Mr. Sutton, my attorney, produced them yesterday.
Okay. And you would agree that these are a fair and accurate...
Counselor, excuse me, we do not have a copy of
Yes,
what you
Judge.
have.
Get a copy for the court.
Continue.
Yes, Judge. You would agree that these are a fair and accurate
Your Honor,
reflection...
pardon me, Your Honor, we were not given a copy of those. Could we have a copy of them, please?
They gave it to us, so whatever.
Thank you.
I'd ask the record reflect that I have tendered to opposing counsel a copy of their witnesses' text messages.
Let the record reflect.
Now, Mr. Banger, you would agree that these are a fair and accurate reflection of the text messages between you and Ken Paxton in July and August of 2020, correct?
Give me a moment. With the only modification that the first text message is in June.
Okay. Well,
It goes through
your
August.
attorney produced these, so presumably he got them from you, right?
Yes.
Okay. Otherwise, fair and accurate reflection?
Yes, they appear to be.
Judge, at this time, I would move to admit AG Exhibit 1003.
Any objection?
No objection, Your Honor.
Show the exhibit being entered into the record.
Okay.
Admitted to evidence, excuse me.
Thank you, Judge. Mr. Banger, you talked about two very, very, very specific conversations that you had with Mr. Paxton that I think stood out during your testimony. The first one of those was a conversation at Polvo's, correct?
We did, well, Nate Paul was part of that, but we were at Polvo's at lunch together with Mr. Paxton, Drew Wicker, and Nate Paul.
And the second conversation was essentially a conversation that you overheard Jeff Mateer was having, right?
The conversation at the Raga meeting in Atlanta, yes.
Okay. Two separate conversations.
Yes.
Did you provide, I don't recall, did you provide dates of those, specific dates of those conversations during your direct examination?
I do not believe I did.
Okay. Now, you talked a lot about your experience and your resume. I think you've clerked, you've worked at, was it Baker Botts as a partner, right?
I have both clerked and worked at Baker Botts as a partner, yes.
You've worked at executive level positions in 2 attorney general's offices?
Yes.
You didn't get there because you don't have an attention to detail, right, Mr. Banger?
I'd like to think that I pay sufficient attention to detail.
Right, and you document things that are important to you, do you not?
Not always.
Not always? Okay. Well, let's talk about that. You had documented in this case something that you thought was very important, the foreclosure opinion, did you not?
I made a document that outlined my concerns about, you said the foreclosure letter?
Yes, the foreclosure letter.
Well, I was shown the foreclosure letter today, yes.
At this time, I would ask Eric if you could publish the House Board of Managers Exhibit 119. Mr. Banger, this is an email that you sent to Ryan Vassar on September 30th.
Counselor, excuse me, has this been entered into evidence?
My understanding is it has. If not, Judge, I'll ask to enter. It's the House Board of Managers exhibit. At this time, I would offer.
We do not object, Your Honor.
Okay. Admitted into evidence.
Thank you, Judge. Now, Mr. Banger, this is an email that you wrote to Ryan Vassar on September 30th of 2020. True?
Yes.
September 30th of 2020 is after you had the meeting with the other executives about going to the FBI with regard to Ken Paxton. True?
This is at 9:29 a.m. that morning. We had not visited the FBI at that point.
Okay, it's the same day that you had a conversation with the other executive level AGs about going to the FBI, right?
We did on that day.
Okay, and September 29th, September 30th, that's 2 months after you ever drafted the foreclosure opinion that you talked about during your direct examination, correct?
Slightly under, but about 2 months later, yes.
Do you typically write memorandums about things that happened 2 months ago? Yes or no?
No.
Does it stand out to you, or does it seem odd to you to wait until the day that you go to the FBI or the day before you go to the FBI to write a memorandum about something that happened 2 months ago?
No.
Not odd at all?
No.
Okay. Now, to be clear, yesterday during Mr. Hardin's testimony, he at one point said, I think by the end of July, beginning of August, you had been a part of 3 issues that related to Nate Paul, right?
Well, depending upon how you count the open records issues as 1 or 2.
Okay. Well, you have the open records issue, correct?
Yes.
Your involvement in MIDI.
I was involved in MIDI as well, yes.
Okay. And then you've got your foreclosure opinion involvement.
Yes, that is correct. I was involved in all.
And as a matter of fact, a lot of those almost overlapped each other, true?
At the edges and at the margins, they did overlap.
Okay. Now, yesterday you testified to the jury that you had a boiling concern about this, correct?
I did have boiling concern about this.
Now, to be clear, House Boards 119, your email to Ryan Vassar, is the only memorandum and summary that you drafted with regard to any of your involvement with MIDI, open records request, or the foreclosure opinion. Yes or no?
I can't recall.
You can't recall. Okay. Well, we didn't see any other memorandums, have we?
I haven't seen any in the trial today.
Okay. Well, you would have produced it, so you'd know about it, wouldn't you?
I produced everything I had.
Okay. And all we got was this email.
I produced far more than this email.
Okay. Now, I want to backtrack a little bit, and we'll go back to that correspondence between you and Mr. Vassar. You talked a little bit about the time from when you guys came out to the FBI and what happened to you after, okay? I want to talk about that. Eric, would you mind pulling up Article 6 of the Articles of Impeachment? Article 6 accuses Mr. Paxton essentially of terminating or taking adverse personal action against employees for making a good faith report to law enforcement. Would you agree with that, Mr. Bangert?
It says he violated his duties of his office by terminating and taking adverse personnel action against employees of his office in violation of the state's whistleblower law.
Okay. So kind of what I just said, right?
I defer to the document.
Okay. Well, if we read from it, it talks about terminating or taking adverse personal action. So I would like to talk about what happened to you. Now, at no point after you reported to law enforcement were you terminated from your position. It's a yes or no question, Mr. Bangert. Were you fired or were you not fired?
I was constructively discharged.
No. I asked you whether you were fired or not fired, yes or no.
Answer the question.
I was constructively discharged.
Did Ken Paxton say you are no longer an employee of the Office of Attorney General?
He did not say that.
Okay, thank you. As a matter of fact, you resigned from the Office of Attorney General as the Deputy First Assistant Attorney General, did you not?
I did resign.
Okay, and you resigned under the title Deputy First Assistant Attorney General.
That was my title at the time I resigned.
Okay, so you were not demoted from your position as First Assistant Attorney General.
I did not lose my title.
Okay. And as a matter of fact, you were never suspended after you reported to the FBI, were you?
I was not.
Okay. You talked about Mr., I think maybe Webster, but certainly Ken Paxton stripping you of some of your responsibilities, right?
Yes.
One of those responsibilities was the fact that you were in charge of the Special Litigation Division, true?
I was.
Now, that role was actually moved out from underneath you, correct?
That is correct.
And they put it in charge of the division chief that was running that division at the time, right?
My understanding was that Patrick Sweeten was put in charge of that division, yes.
So essentially, Brent Webster promoted an under-level assistant attorney general? Yes or no?
I do not know if he promoted Patrick or not.
He certainly added some responsibility for Patrick, correct?
That was my impression, yes.
And that bothered you? Yes or no?
It came without explanation or warning, so yes, it was troubling to me.
It's possible that Mr. Webster just was promoting somebody that had been, I don't know, giving an exceptional performance at their job.
That was the excuse that he attempted to give me.
That's not what I asked you. I asked you if it was possible.
I don't think so.
Okay. Certainly they wouldn't take a job from Ryan Bangert, right?
That's not exactly what I said.
Okay. Sounded like it. You said that the environment, did you describe it as being hostile after you reported to the FBI?
Yes,
Maybe
it was.
Toxic, right?
It was.
Affecting the ability for people to get their work done?
It was.
Okay. Now, you left and you went to work for the Alliance Defending Freedom, didn't you?
I did.
And in your time, well, that would have been 2020, true?
Say again?
When you left the Office of Attorney General and you went to Alliance Defending Freedom.
Counselor, can you raise that mic up a little bit closer
Sure.
to you? Okay.
Is that better, Judge?
That's much better for
Okay, I'm going to
all
lean
the
in here.
jurors.
Yes.
When you left the Office of Attorney General and went to Alliance Defending Freedom, that was in October, November of 2020.
November of 2020.
November of 2020. And since your time in November 2020, all the way up until, I believe, 2023, isn't it true that you have brought cases from the Alliance Defending Freedom to be co-handled with the Office of Attorney General?
We have.
Okay. And some of those cases you have worked directly with Brent Webster, have you not?
There have been some, yes.
Specifically, State of Texas versus Xavier Becerra.
I believe that's the title of the case in Lubbock, Texas.
Okay. And that was one of a few cases, true?
Yes.
And all the while that you were bringing cases from Alliance Defending Freedom back to the Office of Attorney General, Brent Webster was acting as first assistant, true?
That is my understanding.
Okay.
Yes.
And Ken Paxton was acting as Attorney General.
Yes.
All right. I want to talk to you about the open records request, okay? You kind of gave us an explanation of how the process works, so I just want to rehash that out. My understanding is that if an individual makes a request to a state agency, that state agency has a certain time period to go to the Office of Attorney General and make a request for a ruling, right?
There is a statutory time period to request a ruling, yes.
Right. So in this case, the statutory time period, well, for example, when Nate Paul went to the Department of Public Services in March of 2020, if that was March 3rd, they had till March 13th essentially to request your office give an opinion. True?
I do not recall the specific dates, nor do I recall whether it was Nate Paul or one of his attorneys who made that request.
Okay. I just want to clarify, you do not recall the specific dates in which the DPS request by Nate Paul's attorney was made?
It was in the spring of 2020, but I don't recall the precise dates. I'd have to see some documents around that.
Eric, would you mind pulling up Article 3? And while we're doing that, just for a little background, Mr. Bangert, the requests by Nate Paul's attorneys for the records involved in the investigation, it was for initially the Texas State Securities Board, right?
Yes, the initial request went to SSB.
That was in 2019.
Is that a question?
Yeah, that was
Yes,
in 2019.
Yes, it was.
Then you've got DPS. That request was made in the spring of 2020.
That is correct.
And sometime later, arguably end of May, there was a request made for FBI's comment or brief on the DPS request that was originally filed in the spring, right?
I believe that was part of the second request.
Okay, so we're talking about 3 different records requests, correct?
I would classify it as 2 with a secondary request attached to the second.
Okay. And then you also have to throw in the request for reconsideration, right, on the Texas State Securities Board.
That was part of the first file.
So essentially, the Office of Attorney General makes 4 separate decisions about records relating to Nate Paul.
We made at least 3. I don't know if it was 4.
Okay. Well, let's go back to fall of 2019. Texas State Securities Board. At that time, was Ken Paxton the office of he was the AG of the Attorney General's office, right?
Yes, he was.
Now, when Nate Paul made that request through Aaron Borden, his attorney, in fall of 2019, that initial request was denied by the Office of Attorney General, was it not?
Yes, the ORD did, well, when you say denied, it sustained the request for exemptions and exceptions by the board.
Sure, meaning that the Texas State Securities Board, while Ken Paxton was AG, was not required to turn over records to Nate Paul.
That's right, the November request did not require turnover of records.
Let's move forward to 2020. you had a conversation with Justin Gordon about a request for reconsideration of the Texas State Security Board records, true?
I did.
And ultimately, you ended up having conversations with Ken Paxton about that request for reconsideration.
I did.
And ultimately, the Office of Attorney General again did not rule that the Texas State Board, the Texas State Securities Board was going to have to turn their records over to Nate Paul, did they?
We did not require them to turn their records over.
Okay. So up until, that puts us in February or March of 2020, would you agree?
We're ballpark in that area, yes.
Right, ballparking it because yesterday you stated it was right around the time COVID started.
Yes.
That's a whole nother convo we'll get into in a little bit. Okay, so Texas State Securities Board records are not given to Nate Paul. Let's move on to DPS. Now, to be clear, the ultimate decision by the Office of Attorney General with regard to the DPS records was that they refused to rule in that situation.
It was a no decision.
Okay. Now, I want to talk to you about what that means. If the Office of Attorney General refuses to rule on a records request, that means that the state agency that was requested does not have to turn their records over to the individual, right?
We did not require disclosure based on that ruling.
Okay. And so, as a result of that ruling, the Department of Public Safety did not turn their records over to Nate Paul or his attorneys, true?
That ruling did not require disclosure.
Okay. Well, you're aware that there was a writ of mandamus filed by Nate Paul's attorney for those records they were trying to get from you, correct?
You're going to have to, the writ of mandamus, I believe, occurred with respect to the initial request. I don't recall one on the second request, but it may have happened.
You would agree there was a writ of mandamus filed?
At some point, it was my understanding that a writ had been filed.
Okay, and you're not going to tell this jury when that suit was resolved, are you?
No.
For a matter of fact, it could have been pending into the winter of the next year, true?
As far as I know, and for clarity, when you say a writ of mandamus, I'm assuming you're talking about federal practice.
No, I'm talking
about
about writ of mandamus in the district court for the Department of Public Safety records.
You're talking about the second issue then? Okay.
Yeah.
No, yeah, there was a pending action in the district court.
Okay, so they weren't just going to Office of Attorney General to try and get these records that they were after, right?
Could you repeat one more time?
They weren't just going to the Office of Attorney General, Nate Paul and his lawyers. They were also going to the district court to try and get the records they were after, correct?
That was my understanding.
Okay. Now, DPS was not required to disclose records after this refusal to rule, right?
Our refusal to rule did not require them to disclose.
You stated that that was contrary to precedent at the Attorney General's office, true?
I did.
But you would have to admit that this specific request made by Nate Paul and his attorney Joe Larson had some unique circumstances, true?
I don't recall any unique circumstances.
Well, you worked with Justin Gordon pretty closely on this case, didn't you?
I worked with him very closely on the first file for SSB and somewhat, but less closely on the second file.
Okay. Could you kind of, so you really delegated it to Justin Gordon to handle, right?
No.
He was the man in charge of this decision, was he not?
He was the head of open records, answering to Ryan Vassar, the deputy for legal counsel at the time.
And he drafted opinions, and he drafted the opinion to refuse to rule that you edited, true?
I did edit the opinion.
Okay. Your Honor, may I approach the witness?
Yes, you may. Just don't talk on your way up or back.
Yes, Judge. I guess the point I'm getting at, Mr. Bangert, is that not every, like you said yesterday, you said that pretty much all of these requests are kind of the same. They're easy to rule on when it comes to law enforcement material, true?
They're not all easy, but we get a lot of them.
Right. You referenced the opinion, the law enforcement exception, true?
Yes, I believe that's correct.
That doesn't
When you say the
necessarily...
opinion, which one are you referring to, though? I want to make sure I'm answering accurately.
Well, the DPS opinion
I believe that's correct. I need to see it again.
and the FBI comment.
Again, I need to see the document.
To be clear, there was an initial request for DPS records in March of, or spring of 2020, true?
That is my understanding, yes.
Okay. There was a later, you're aware that DPS did not notify the FBI about the records, true?
I don't recall that. You'd have to refresh my memory on it.
So it sounds like you don't know every little detail about the records request, do you?
No, and that's perfectly normal for a senior executive
Okay.
not to know every detail.
So yesterday when you said that the decision was not consistent with precedent, you didn't know every little fact about what was going on within this request, did you?
I knew enough to make that determination.
Well, you didn't know everything, did you, Mr. Bangert?
I am not omniscient, so no, I did not know everything, but I knew enough to make that determination.
And it's fair that maybe Mr. Gordon had a different opinion about what went on with regard to those records requests.
Mr. Gordon was working on that. I do not recall what his opinion was.
Okay. Are you aware that ultimately the Office of Attorney General did disclose the FBI comment?
I do not recall that.
Okay. Are you familiar with June Haddon?
June Haddon, the name is familiar. I believe she worked in the Open Records Division.
Okay. Would it surprise you to find out that she ruled that the FBI's brief on the DPS record should be disclosed to Nate Paul and his attorneys?
I'm not aware of that, but I'd have to see the ruling.
Okay. You hadn't heard her name with regard to this litigation or case today, have you?
No, not until today.
Okay. And you have no opinion as to whether Ken Paxton prodded June Haddon to turn those records over to Nate Paul, do you?
You'll have to ask the question again. It was coming fast.
There's no evidence, you don't know of any evidence, or you have no opinion that Ken Paxton told June Haddon to turn the FBI comment over.
I'm not aware of any conversation to that effect.
Safe to say that in conclusion, every single request for records from Nate Paul's lawyers, none of those resulted in him getting the records with regard to DPS and Texas State Securities Boards, right?
I'm not aware of any disclosures that were made,
Okay.
at least by our office formally.
So essentially every ruling that was made with regard to those records was the same, had the same effect as if you refused to require DPS or Texas State Securities Boards to turn those records over.
The net result was they did not have to disclose the documents.
Okay. You were involved with Biddy as well, right?
Yes.
Now, you talked about the fact that Ken Paxton directly ordered you to intervene into the lawsuit, true?
Yes.
Now, you would agree that if you thought something was illegal, you wouldn't want to delegate it to a lower level attorney, true?
That I don't even know how, no, that does not.
Yes or no? Would you delegate illegal activity to a lower ranking attorney?
The question doesn't make sense because I wouldn't carry out illegal activity.
Judge, I'd asked a non-responsive. I've asked him a question.
Answer the question.
Yes or no?
I would not instruct anyone to carry out illegal activity.
Right, that's why you didn't have Ryan Vassar sign that opinion in July of 2020.
I did not have him sign that opinion because I had a very bad feeling of where that was headed.
Okay. Well, let's talk about what you did in the Biddy case. You had no problem instructing, well, let me rephrase that. You did instruct Josh Godby to intervene into the Biddy case, did you not?
I did.
And when Ken Paxton asked you to file a motion to stay, you told the jury that you were opposed to filing that motion to stay, did you not?
I did.
But you turned around and you asked Joshua Godby to file a motion to stay in that case, did you not?
I don't recall that.
Okay. He filed a motion to stay, didn't he?
That is my understanding. Eventually, a motion to stay was filed.
Okay. You didn't walk up to Ken Paxton and say, Ken, I don't agree with what you're doing, and so I'm not going to do it.
I did not have that conversation with him, no.
And at no point did Ken Paxton say to you that if you do not intervene into the Mitty case, that you're going to be fired?
No, we never had that conversation.
You are aware that Mitty has been previously of interest to the Office of Attorney General, true?
You'll have to refresh my recollection.
Okay, well, when Greg Abbott was the Attorney General, you're aware that the Office of Attorney General filed suit against Mitty.
Yes, that did happen.
Okay, so you are aware that their background isn't necessarily squeaky clean?
I wouldn't put it that way.
Okay. You would not tell, you've got no knowledge that Ken Paxton was entering into the Mitty litigation for the purposes of benefiting Nate Paul, would you?
Well, I disagree with that.
Okay. Do you have personal knowledge? Yes or no?
I do.
You do?
Yes.
Well, Jeff Mateer made you aware of the fact that Jeff Mateer made you aware that World Class was disgruntled and not happy with Joshua Godbee's performance in the intervention in Mitty. True?
That was some time later, but I received an email, I was copied on an email, in which Jeff responded to current counsel for World Class, complaining about Joshua Godbee.
Okay. So World Class was complaining about Joshua Godbee. True?
They were.
Okay. Now, at some point, you stopped talking to Joshua Godbee. I want to say that was, excuse me, let me back up. You stopped talking to Justin Gordon about the open records request. True?
At some point, the issue came to a rest,
Right,
so I would have no occasion to talk to him after.
Probably when you made the final ruling not to disclose the records in the Department of Public Safety request.
When the no decision was issued, yes, that's when it would have terminated.
Now, about 1 or 2 days after that, it might have been June 2nd, you started talking to Joshua Godbee about the Mitty Foundation case. True?
That sounds about right, yes.
And Ryan Vassar has his hands in the open records request at that time, too. True?
He was overseeing the Open Records Division.
Because he took your position, right?
He did when I was promoted.
Okay. So Ryan Vassar is also probably aware of these different interactions with Nate Paul between the Office of Attorney General and Nate Paul, correct?
You'll have to ask him that question.
Okay. Well, safe to say that he worked on the open records request with you, right?
He worked on it, yes.
And he worked on the foreclosure opinion with you, true?
He did.
Okay, so those are two different scenarios where you and him both worked on Nate Paul issues, true?
At least those two.
Okay, and it's fair to say that you and Mr. Vassar were discussing the fact that you both had been involved with Nate Paul.
At what time?
At some point when you were working on these cases.
We had discussion around those two instances. We discussed the work that we were doing.
Okay, so you would not tell our jury, the senators, that the executive level attorney generals did not know that different divisions or facets of the office were involved with or working on cases regarding Nate Paul, would you?
We began to piece together the linkages between these matters over time.
Okay. But you didn't do anything about it until September, I want to say 30th of 2020, true?
That's false.
Well, you didn't go to the FBI until September 30th of 2020?
We didn't go to the FBI.
Let's talk about that foreclosure guidance. Eric, would you mind pulling up Article 2? And to be clear, Ken Paxton is allowed to intervene into a lawsuit if he thinks it's appropriate, true?
Our office has authority to intervene.
Okay. And he's in charge of the office, is he not?
He is the elected Attorney General.
Okay. So if he wants to intervene in a lawsuit, he is allowed to do so.
He has authority to do so.
Okay. Looking at Article 2, it alleges that Mr. Paxton misused his power to issue written legal opinions under Subchapter C, Chapter 402 of the Texas Government Code. You're aware of this, right?
Yes, I see the article on my screen, yes.
Okay. Now, we actually looked at a copy of that exhibit. Eric, would you mind entering Exhibit 192, AG 192? And Judge, for the record, I believe it is an exact copy of a House Board Manager exhibit that they've already published. Would you scroll to the second page, Eric? And just to be clear, Mr. Banger, when we talk about that very last paragraph, you actually signed this opinion, right?
Yes.
Okay. And by signing it, you would agree that you have adopted the statements within it, true?
Not necessarily.
Okay. So you just sign things at will?
No.
No? Okay. And you signed this document, right?
I did sign this
And
document.
the very last sentence or paragraph in that document says, it is not a formal opinion under subchapter C of chapter 402 of the Texas Government Code, true?
Did you scroll down to the last paragraph?
Well, you wrote the opinion and you read it a minute ago. You would
I'd
agree
like to
with
see
that.
I would like to see the document.
I think I've got a copy.
There it is.
Got it. You wrote, we trust this letter provides you with the advice you were seeking. Please note this letter is not a formal Attorney General opinion under section 402.042 of the Texas Government Code. Rather, it is intended only to convey informal legal guidance.
Yes.
You wrote that, right?
I did.
That was on this letter when you issued it in 2020, right?
It was.
Okay. So the very face of the document that you signed specifically states that it is not an opinion under 402, true?
No, that's not correct.
Specifically says it's not a formal Attorney General opinion under section 402.042 of the Texas Government Code.
It is not a formal Attorney General opinion
Okay.
under section 402. It's very different.
Okay. Let's talk about formal opinions. There's a specific place on the Attorney General website for a formal opinion, is there not?
Opinions that are issued are listed on our website, yes. They are assigned KP numbers and they are accessible by the public.
They are signed KP numbers. At this time, Judge, I would move to offer AG Exhibit 6 after I provide a copy to opposing counsel.
If you have one more copy for us, we'd appreciate it.
I've got one more copy for the court.
I have no objection, John.
We'd still like to see it.
Yes, Judge.
Just so we can follow along. All right. Thank you, sir. Admit this exhibit into evidence. No objection.
And Eric, if you would publish and just stay on the first page. So up here in the top left corner, we've got opinion number KP0322. True?
Yes, it says opinion number KP0322.
Okay. And that is an opinion number that is associated with a formal opinion.
I have not seen the rest of this document, but I'm assuming that this has the form and shape of an informal opinion.
Okay. Did you state yesterday during direct examination that Ken Paxton doesn't have a hand in signing or dealing with formal opinions?
I don't believe I said that, no.
Okay. So you would agree that he does pay attention to what he signs and what he issues on his office letterhead, correct?
He is required, or, well, I should say, he has a practice of signing formal opinions himself.
Okay. And that opinion has his name on it, true?
I cannot see it, but I would be welcome to look at the signature block.
Eric, would you flip back to the signature line? Okay. You see Ken Paxton's signature on that opinion, right?
Yes.
Okay. He has to sign these formal opinions, does he not?
I believe that is the practice of the office.
Unless he's been recused, in which event Jeff Mateer would sign the formal opinions, true?
That was the practice of the office.
Now, I want to talk to you about the opinions in this case. Originally, Ryan Vassar drafted the the informal guidance letter with regard to foreclosure sales, correct?
Yes, the informal opinion that was issued on August 1st, he did draft the initial draft, yes.
Now, the way that that letter ruled was essentially that You didn't attack the 10-person restriction from the executive order, right? You just said that judicial foreclosure sales were accepted from the rule and could go on with that restriction.
I would need to see the document to refresh my recollection on the precise contours of the opinion.
Eric, would you pull up Exhibit 192? I mean, Mr. Banger, you drafted this opinion, did you not?
Well, Mr. Vassar drafted it, and I provided edits and corrections to it.
So you're familiar with the content?
I was 3 years ago.
Okay. Well, if you take a look at it, you would agree that it ruled that foreclosure sales could still go on despite the fact that there was an executive order restricting public gatherings outside to 10 people. True?
Please go to the next page. There were very limited circumstances under which foreclosure sales could proceed, but we were subjecting those to the hard 10-person cap.
I mean, you testified with regard to the subject matter of this yesterday, didn't you?
I did.
So you would agree that you said that despite the fact that 10 people at max can gather in public, foreclosure sales can still occur, true?
That misrepresents the opinion.
Well, if there are, you said that foreclosure sales could still go on, did you not? Is that not what that opinion says?
No.
It doesn't seek to invalidate the 10-person rule, does it?
You need to go to the next page of the opinion.
Go to the next page, Eric. Thank you.
The second full paragraph on page 3 has operative language.
Elaborate on that.
Pardon me?
Tell us about that.
If a foreclosure sale is subject to and not exempted from the 10-person attendance limit imposed in Executive Order GA-28, it should not proceed if one or more willing bidders are unable to participate because of the attendance limit.
Okay. So, how are you saying that when Ken Paxton asks you to change the opinion, that it is contrary to precedent and the position of the Office of Attorney General at that time?
It made the ability to proceed with those types of sales more restrictive under the COVID limitations than our previous draft would have.
It made it more restrictive?
Yes.
Right. Which means that, in a sense, it benefited people that maybe didn't have their jobs at the time and didn't have money to pay their mortgages off. True?
I do not know who this was benefiting. At least at the time I was writing it, I didn't know who it was benefiting.
Did you lose your job during COVID, Mr. Bangert?
Say again?
Did you lose your job during COVID?
I did not.
Did you struggle with the ability to pay a mortgage during COVID?
I did not.
You would have to agree with me that many people did lose their jobs during COVID. True?
I understand that that did happen.
Okay, and as a result of losing their jobs, many people probably couldn't afford rent and they couldn't afford their mortgage, right?
I also understand that financial institutions were suffering because of restrictions on their ability to foreclose on their loans.
Excuse
Objection,
me,
non-responsive.
may he please answer the question, Your Honor? Let him be allowed to answer.
Is that an objection, or are you just making a comment?
It is
Okay,
objection.
well, overruled, but let him clearly answer the question, but answer the question directed.
Yes or no? My question was yes or no. Could that affect people and their ability to pay their mortgages and their rent?
Could what affect them?
A ruling that foreclosure sales, or excuse me, that COVID was in existence.
COVID was in existence at that time.
And it caused people not to have money and not to be able to afford rent and not to be able to pay their mortgages. True?
I believe the economic disruption caused by COVID had some of those effects.
Okay. And the job of the Office of Attorney General is in part to protect the public. True?
The Attorney General's office is a sacred trust, and it's always to be used for the public benefit,
Right. Now,
all of the public.
Eric, could you publish Exhibit 119 again? This is your memorandum of what happened with regard to the foreclosure opinion. And you stated in Exhibit 119 that you were not certain why Ken Paxton wanted this foreclosure opinion issued. True?
There's no exhibit on my screen.
119, Eric.
May we see it, please?
I think it's been entered, Rusty.
I said, we don't have it.
Oh, I understand. Eric's pulling it up.
We don't have a copy.
It's y'all's exhibit.
Is it in evidence? I don't think it's in evidence.
It's in evidence, Judge. I've already referenced it during this examination.
He submitted it earlier. You didn't object, I believe. Oh, I believe that's the case.
If that's
Yes,
the case.
no, this, I
If that's the
recognize.
case for an error, but I don't think we had it marked as in evidence. Thank you very much.
Yes, sir.
You stated that you were uncertain why Ken wanted the foreclosure opinion issued. True?
He had provided me a rationale.
It's a yes
for-
or no. You said in this memorandum right here, you were uncertain.
I was uncertain.
Okay. Now, you did not include the fact that Ken Paxton was texting you all the while you were editing and drafting that report, did you?
I don't believe I mentioned text messages in this document, no.
And yesterday you told all the senators that it was contentious between you two on the phone at some points, did you not?
Oh, I don't recall saying that.
Okay. So it was calm and collected the entire time.
It was not calm and collected the entire time.
Okay. Well, you stated to them that you were objecting vehemently over the phone with Ken Paxton, true?
I did not say that.
You were objecting to Ken Paxton, were you not?
I was having conversations with him in which he was frantically telling me to make edits, corrections,
It's
and
a yes or
ultimately
no question.
changes.
It's a yes or no question, Mr. Bangert. You disagreed with Ken Paxton over the phone, true?
I had conversations with him about the contours of the opinion.
Okay, so you're not saying you disagree with him then, are you?
I was trying to understand what he wanted as his subordinate.
Okay. You didn't mention text messages yesterday, did you?
I did not.
All right. Eric, if you would flip to AG 1003 for me. Now, Mr. Bangert, you stated on direct examination yesterday that, quote unquote, Ken Paxton was acting like a man with a gun to his head. Did you not?
I did say that.
Okay. Now, looking at the last set of text messages here, if you'd flip to the last page, Eric. I'm just going to read from the exhibit. Thank you again. I can't express in words how much I appreciate your work, especially over the weekend. I am grateful because I feel like hundreds of people will be protected from harm and maybe devastation. You and Ryan deserve all the credit. Thank you. I hope that your Sunday is relaxing and enjoyable with your family. He texted that to you that day, didn't he?
12:19 on Sunday. Yes.
Okay. Now, did you mention that to the House Board of Managers when you were interviewed about this case?
I don't recall if I mentioned this text message.
Did you mention these text messages in your interviews with Mr. Harden or Mr. DeGuerin when you were preparing for testimony in trial?
I don't see why I would have.
Okay. And did you include it in your memorandum to Ryan Vassar that was produced?
There's no reason why I would have.
Showing gratitude and why he wanted to have this foreclosure opinion worded the way he did?
I don't believe that he was telling the truth.
Well,
Sure.
certainly not a text message from you in these texts objecting or saying that you disagree with Mr. Paxton, is there?
I do not agree. I do not disagree with him here.
You don't disagree with him here.
I do not state it in writing here.
Okay. You signed the opinion that was ultimately issued in this case, true?
I did sign it.
And that opinion has no binding effect,
It is a persuasive opinion.
persuasive at best.
Persuasive opinion.
Okay. Did you tell the FBI about these documents?
I believe they were provided to the FBI.
Okay. We just didn't get a copy of them until today.
I did not have them in my possession.
Oh, okay.
They were in the possession of my counsel who found them.
Did you delete
recently.
your texts?
No.
So you would have had them on your phone, true?
No, I did not intentionally delete my texts.
Okay.
My
Your
texts are no longer.
Your
I no
texts
longer
were
have access
deleted,
to
yes
them.
or no?
Gentlemen, don't talk over each other.
Your texts were deleted, yes or no?
I no longer have access
It's
to
a yes
texts.
or no question.
I no longer have access to texts past 1 year.
Okay. So in the year, you didn't think to take screenshots of these?
Excuse me?
You didn't think to screenshot these messages?
These were screenshotted back in 2020.
Okay. You just didn't keep a copy?
I did not.
And you're not going to sit here and tell us that you know that the foreclosure opinion ultimately affected or benefited Nate Paul, are you?
Oh, I believe it did affect and benefit him.
You have no personal knowledge of that, do you?
I have since learned that it did benefit him.
You wrote in that memorandum that you learned through the Austin Statesman, did you not?
May I see the memorandum again?
Eric, would you please pull up the memorandum? That's a newspaper, correct?
The Austin American Statesman?
Yep.
Yes.
Okay. So you got your information from a newspaper, did you not, if we're believing your memorandum?
If I could see my memorandum, I can tell you.
Oh, Eric, would you? 119, Eric. Thank you. I think it says on the following week, on August 4th, the Austin Business Journal, excuse me, I stand corrected. The Austin Business Journal reported that World Class had placed several properties into bankruptcy.
So it did.
Are you aware of when the foreclosure was supposed to take place?
I was not aware of any foreclosures of Nate Paul properties when I was writing the opinion.
No, I'm talking about after. I'm talking about August 3rd and August 4th. Were you aware?
I subsequently learned that that was taking place.
That the foreclosure was supposed to take place on August 4th.
That I don't know for sure, but it would have been the statutorily appointed date, whatever that was, in 2020. And yes, now that I'm looking at my document, I do say August 4th, so that would have been the date.
Okay. May I approach the witness, Judge? Just to hand him
Yes,
the
you may.
document. And Judge, at this time, I would offer AG Exhibit 295.
Any objection?
May I have just a second? I'm
Sure.
sorry, Judge. Thank you. No objection?
We'll enter, what was the number on that? I don't have a number on that.
295, Judge.
Enter 295 into evidence.
Eric, would you mind publishing AG 295? That is a letter from Sheena Paul to the judge regarding the bankruptcy the foreclosure proceeding occurring the next day, dated August 3rd of 2020, correct?
This is executed by Brian Elliott.
Attorney for World Class, right?
I assume so because it has World Class's, one of their property names at the top of the letterhead.
You would agree that this document has the letterhead of August 3rd, right?
It is dated August 3rd.
Now, you were not present in the district court when this document was filed, were you?
No.
So you have no idea what impact it had on the district court judge in that proceeding, do you?
I have not talked or spoken with Judge Gamble about this, no.
Now, the very next day, the day that the foreclosures are supposed to occur, you find out that a bunch of Nate Paul properties are put, world-class properties are put into bankruptcy, right?
That's what the Business Journal reported.
Okay. You've been in civil practice for quite a long time, true?
Over a decade at that point.
You are very, very aware of what happens to properties when you file bankruptcy, are you not?
I was not a bankruptcy practitioner.
Well, surely you're aware that when you put a document, or you file bankruptcy on something, it causes a motion to stay, does it not?
There's an automatic stay that's applied based on my recollection.
There you go, which would prevent any type of foreclosure sale, would it not?
Again, I am not a certified bankruptcy practitioner. I know that there are exceptions to that. I can't even begin to speak to the legalities of these properties or how those would have applied in these cases.
Well, you knew a lot of law, on direct examination with Mr. Harden, and now you don't know about bankruptcy proceedings?
Mr. Harden did not ask me about bankruptcy proceedings.
You had no problem putting in your memorandum that the properties went into bankruptcy.
The properties were going into bankruptcy, that's correct.
Okay.
Sorry, they were going to foreclosure.
It's possible that the bankruptcy filings did not, or those are what prevented the foreclosures. True?
I don't know.
Okay. Well,
but I think it's interesting that World Class submitted a copy of our
objection to non-responsive.
Opinion.
Objection to non-responsive. May I approach the witness, Judge?
Yes, you may.
I would like to offer AG exhibits that I've handed to both opposing counsel as well as Your Honor. I believe it's 262, 265, 275, and 283.
Hold on, slow down. 283, 275, 265, 262?
Yes.
I can shorten this a little bit. If he represents that these are their exhibit numbers that were originally agreed to, that we said we would not object to any of your exhibits.
Okay.
If they're covered by that objection, if they're covered by that agreement, then we have no objection.
Are they covered?
They are covered, Judge. Well, take that back. No, they're not. That's why I intend to offer right now. We have not previously agreed to these.
I understand. Just give me a couple more minutes then. I don't care. No objection, Your Honor.
Can you just clarify for the record, we have one with a number and what the other numbers are? You may have the copies back.
So for purposes of the record, we're offering 262, 283, 275. I only gave you, and then also 269.
No objection 269 was a new number from the one you repeated back to me.
Yep.
Just want to be clear.
269, 275, 283, and 262.
I think I said 265. You repeated what I said. I was incorrect. It's 269.
Okay.
There's been no objection? I believe they said no objection. Mr. Harden, you said no objection, correct? Yeah.
Sorry, Judge.
Please enter those documents into the record,
Just going to okay. Thank you.
into evidence, excuse me.
May I approach the witness, Judge?
Yes, you may.
There's got to be something.
These are all bankruptcy filings by Nate Paul and his attorneys made on August 4th and August 5th, okay?
Say so.
All right. Now, if these bankruptcy filings were filed on August 4th, the date that the foreclosures were supposed to occur, that would stay the foreclosure sale, would it not?
I don't know.
You don't know.
Perhaps.
So it's possible that Ken's issuance of the informal guidance letter didn't cause the foreclosure sales to go away. It's possible.
I do not know what effect that letter had
Okay.
on the foreclosure sales.
Are you a Trump fan?
I'm sorry?
Are you a fan of Donald Trump?
I voted for President Trump.
Okay. You're a staunch conservative, are you not?
I am.
Are you aware that only a week after you guys issued this opinion, he issued an executive order that basically mimicked the attitude towards foreclosure sales?
I'm not familiar with that executive order.
Okay. And so that brings us into the fall of 2020, right? August, September?
September is the beginning of fall.
Okay. And you didn't really have any contact with issues regarding Nate Paul from August of 2020 up until September 28th, right?
Oh, I disagree with that.
Well, you weren't working on the
The
foreclosure
witness,
opinion.
please speak up when you're...
Yes, I disagree with that.
You were not working on the foreclosure opinion.
That was completed on August 1st.
Okay. You weren't working on MIDI.
Mr. McCarty had assumed responsibility for that.
You were not working on MIDI.
I was not working on MIDI at that time in August.
And you were not working on the open records request, true?
Those were finished.
Okay. So you were not personally working on any matters that involved Nate Paul at that time.
I was actively speaking with other members of the executive team about what was happening at that time, which was the desire to hire outside counsel.
So everybody, I assume, is on the 8th floor at this time, right?
We had COVID orders were still in place. I don't recall who was there every day. I was there every day the office was open.
And let's talk about that, because the OAG's position at that time was that everything should open up, was it not?
We wanted everything to be as open as possible, consistent with public safety and the governor's orders.
Even after you left the Office of Attorney General, your employees at the Office of Attorney General weren't even present.
There were some who were not present.
There were some. There were most of them that were not present.
My recollection was there were periods of time where large majorities of them were not working from the office.
Periods of time that postdated your employment at the Office of Attorney General.
I cannot speak to that.
Because you weren't there.
Because I was not there.
So that's not really inconsistent with the situation that was going on at the Office of Attorney General, was it? Yes or no?
That the attorneys were
Yes,
not
sir.
present?
Yes or no?
Oh, that had nothing to do with our policy.
Okay.
Nothing.
So you were not personally a part of the hiring of Kamek, were you?
No.
You found this out on September 29th of 2020.
That he had been retained by the Attorney General directly?
No, that he was filing subpoenas with Michael Wynn.
Yes, I learned about that on the 29th.
And you're saying that that is the very point that it kind of stood out to you all what was going on, right? That was the tipping point.
That crystallized a number of things.
Okay. Now, when you say it crystallized a number of things, you did not have all the facts with regard to that investigation, did you?
I personally did not.
Okay. You didn't investigate that case, did you?
Was I... What do you mean by I wasn't investigating that case?
You didn't investigate the referral that was given by the Travis County District Attorney's Office, did you?
I was not the primary responsibility for that.
Everything that you took with regard to that investigation came from Mr. Penley or Mr. Maxwell.
No,
Those were the people responsible for investigating it, were they not?
they were responsible.
Okay. You were not responsible.
That was not part of my responsibility at that time.
Okay, so you weren't responsible. Now, despite that fact, you went to the FBI on September 30th, correct?
I did go to the FBI on September 30th, yes.
You went to the FBI without talking to Ken Paxton first, true?
Oh, I talked to him many times prior to that.
You didn't talk to him about the fact that you were going to go to the FBI, did you?
We did not talk to him. We did not tell him we were going to the FBI immediately prior to going.
Right. So when you and Mr. Harden were talking about the conversations you had with Ken Paxton about the fact that you wanted to talk to him, that was all after you had already gone and reported your boss to law enforcement, true?
The text messages that we reviewed today were sent after we made our good faith report.
Okay. So you did not take the time to hear his side of things out before you went to law enforcement?
I disagree.
And at that point, you took it upon yourself to send a letter to Brandon Kamick as well, did you not?
If I can recall correctly, I was the one who did send the email containing Jeff's letter. Again, I'm stretching my memory, but I think I was the one who sent it.
Okay. Now, prior to doing that, you talked earlier about a set of text messages. I would ask to admit, to publish House Board Managers 225. Eric, would you? It's been admitted, Judge.
And Council, we're going to be going to the lunch break. I've gone a little longer, a few more minutes. Do you want to break now, or do you want to continue for
I'm
a few
fine
more
right
minutes?
now, Judge.
Is good for you now?
Yep.
Okay, we'll break for lunch now.
Your Honor, I apologize. Can I raise one issue? I apologize, Your Honor. Can I raise one issue before we break for lunch?
Yes.
That may just help speed things along with this witness. You admonished Mr. Harden at the beginning of the day that if there were any statements that Mr. Bangert had provided that we haven't seen, that he was to turn them over to us. The witness has testified that there were actually 2 interviews that he gave to the House. We still don't have any information related to those. To the extent that there's work product mixed with that, I think they can redact that and provide us the statements. But I just request that we get those over the lunch break, and that may allow us to not have to recall the witness later.
Just continue to look during lunch break for those documents if you have those.
Thank you very
And
much.
if you do, turn those over by the end of lunch.
Sir, we do not have, but I'll continue to be sure. Thank you.
We will return at 1:10.
I don't either, because this is our whole theory.